The first part, what is the effect of a declaration of constitutional invalidity of any law by the High Court in a constitutional application? The second part, state any two procedures by which an order of constitutional invalidity or validity by the High Court may be brought to the Constitutional Court for determination. What is the effect of a declaration of constitutional invalidity of any law by the High Court in a constitutional application? Pass. All right.
Yes.
All right. We can proceed. The second question, which is also in two parts.
No, I wanted to answer the first part of the first question.
You want it? Sorry.
I want to answer the
Oh, you want to answer?
To answer, yes. Thank you, CJ. If a matter is or legislation is declared to be constitutionally invalid or is not of efficacy in the High Court, that particular legislation is not struck down. It will be struck down, but then there should be confirmation proceedings that should be brought before the Constitutional Court to either confirm that particular declaration of invalidity or efficacy of that particular legislation that is being struck out by the High Court. There are two cases to that effect. The one that involved corporal punishment. I think it was a judgment by Justice Muremba. It was brought to the Constitutional Court for confirmation of the invalidity of the law pertaining to corporal punishment of juvenile young boys. And then it was actually confirmed by the Constitutional Court. And then there is another matter that was not confirmed by the Constitutional Court, where the High Court had actually struck down on the basis of invalidity and efficacy the matter of Kwanese versus the Minister of Finance. The Constitutional Court decided not to confirm the constitutional invalidity of that particular law. And then the second one, the procedure, two procedures that can be used to bring the matter to the Constitutional Court. I do believe the rules provide for those procedures, that once the matter has been once the matter is before the High Court and the High Court has decided that it should go for confirmation, the registrar plays a big part in actually letting the matter go there to the High Court. And then the second scenario will be in terms of section 175 subsection 3, where an interested party or anybody who has got wants that matter, who want to appeal against the invalidity, can actually approach the court directly, that is the Constitutional Court directly, in order to have that matter either confirmed or he can appeal against it. Those will be my answers to the first question.
Yes. The second question, which is also in two parts. The first part, what are the exceptions that must be taken into account by a court when deciding whether or not to grant specific performance in a contractual dispute? And the second part, what is the test which a court applies in the determination of an application for absolution from the instance?
If I may skip the first part and answer the second part, the test that is applied in a case of absolution from the instance. Really, the test is not very different from the state that is applied when it comes to criminal matters of an application for discharge at the close of the state case. Once the plaintiff has actually laid evidence and closed its case, he can make an application for absolution from the instance, and the court will look at the application and see whether after it actually said we are not going to go to the defense, or we are not going to go to the defense, it then decides whether, if the matter were to go to the defense, is the evidence, is the plaintiff's case, if it is put on the scales, can he actually get the particular judgment that he actually wants, or can he actually prove his case?
Yes, the third question is in three parts. The first part, state any two components of sentencing judgment. And the second part, how does a sentencing judgment under the sentencing guidelines, regulations, differ from the previous practice of giving reasons for judgment? And then lastly, what is the role of the victim impact assessment statement?
If we may come again, Honorable CJ, two components of them. May I repeat the question?
You want all the three of them?
Yes.
State any two components of a sentencing judgment. Then the second part, how does a sentencing judgment under the sentencing guidelines, regulations, differ from the previous practice of giving reasons for judgment? And the third part, what is the role of the victim impact assessment statement?
The two components, that is the first part of the question, the two components of the sentencing judgment is that first, there should be an introduction that the offender was brought before this court, or was convicted, was charged with a particular crime. And then the second part may be that he was then convicted on that particular charge, or the alternative charge, or the permissible verdict. And the other part is that he actually entered a plea of not guilty, or it was a plea of not guilty. And the other part may be that the court will have to lay down the facts found to have been proven. That is the answer to the first part. And then the second part is the difference of the sentencing judgment from the one that used to be there, is that the sentencing judgment in terms of the statutory instrument 146 of 23 now has got a format. We have to follow a certain format in actually sentencing. We have to investigate, first of all, what you call a pre-hearing, a pre-sentence hearing. Once you have conducted a pre-sentence hearing, then there is a format that you are also supposed to follow. The pre-sentencing hearing also informs the court what it is supposed to ask when actually making an investigation as to what appropriate sentence it may give. It can actually look at the characteristics of the offender and his social background, the characteristics of the victim and the impact, and then whether the offender is likely to commit other offenses, whether the offender is willing to pay restitution, and so on. So after you had investigated that in the pre-sentencing hearing, then you look at the format that is given. You look at the introduction, you look at the plea, you look at the facts that were proven. If there are any exhibits that were produced, you mention them and put the effect thereon. And then you look at the law that is required, that the presumptive penalty for that, and then you also go down and look at the aggravating factors and the mitigatory factors, and then you pronounce the sentence. So there is a very clear format that should be followed. And then the third part of the question is it says, what is the, if we may repeat it, Chief Justice, the victim impact assessment statement.
What is the role of the victim impact assessment statement?
Thank you for that, Chief Justice. The role of the victim impact assessment statement is that the victims are now take a part, actually have an input in the sentencing of an offender. In olden days, the voice of the victim was never heard, but nowadays, because of that statement, of the new procedure, the new regulations, the victim has to depose to an affidavit or a form to show the psychological effect, the financial effect or prejudice that could have been occasioned to him, and any other prejudice that could have been occasioned to him by the commission of the offense. So the victim impact assessment statement plays a very big role in actually informing the court as to the sentence that might be reached. Because at the end of the day, my understanding is that these particular regulations that came in terms of Section 334A of the CP&E Act was that the victims of the offenses did not have a word as far as the sentencing of the punishment of the offender was concerned. Now they have a word. They can inform that, look, I suffered so much. And then there is a question that is asked as well, what do you want to be done to the offender? And then the victim will say, you can send him to prison or you can give him community service. He has restituted me, and so on. And so the sentencing court will take all that into account. I think that is the role.
The fourth question is also in two parts. The first part, how have the High Court amendment rules 2024 addressed the key concerns of access to justice on the IECMS platform? And the second part, state 3 ways in which the IECMS has revolutionized civil litigation in Zimbabwe.
maybe if you can repeat so that I can answer properly, Honorable CJ, the first part, the amendment part.
How have the High Court Amendment Rules 2024 addressed the key concerns of access to justice on the IECMS platform?
Thank you, Honorable Chief Justice, for the question. The amendment to the rules, that is a statutory instrument 81, number 81 of 2024, that came into operation recently, replacing or repealing statutory instrument 153 of 2023, has actually increased the access to justice for the litigants. What has happened was there was the issue of access to the internet, access, that is connectivity. There were concerns that were raised about virtual hearings. There were concerns that were raised about the distances to be traveled. I'll give those three instances. The distance to be traveled, according to the amendment, statutory instrument 81 of 2024, the litigant who has got matters that are in the civil court of the High Court, the commercial court, or that intends to use the IECMS platform, has to go to the nearest courthouse, which is called the e-filing centers, where the court or where the registrar has to make available all the things that are necessary for the litigant to actually access those platforms. And the issue of also connectivity, the rules, the amendment to the rules has made it very easy for the litigants, especially in remote areas, who may not have, for example, data bundles, who may not have maybe compatible gadgets for the virtual hearings. They can also go to the nearest e-filing centers, the internet hub, for example, in High Court Bulawayo, or in Eskodini, or in Cholocho, or Binga, or Mzaraban. They can actually go there, and the filing part of it is actually for free. And then also the tools of trade that are going to be used there, they are actually for free, and they should be provided. If there is a power outage, the Registrar General, according to the amendment, there's to make arrangements that those are attended to. Of course, there'll be supervisory role by the court that is in charge of that particular setup, that everything is seamless, is efficient. And also there are e-filing officers there who are going to assist those who are not maybe computer literate, who are not computer savvy, to actually log in and do all that is needed. And then the amendment has also brought in the issue of virtual hearings. There was the issue of where a party does not want to go a virtual, did not want the hearing to be virtual. The amendment provides that before you can talk about the hybrid nature, the parties have to be notified 10 days before the set down date that this matter is going to be virtual, and the parties have to do so in writing. They have to inform the registrar in writing 10 days before this to say, are we going to actually have this matter heard virtually or not? So the parties still elect whether to go virtually or not. But if the parties are not agreed again, the judge that is in charge of that particular court has got the final say in the interest of justice, whether the matter should be heard virtually or there should be physical appearance. And then the other issue is where one party says, I want to attend physically, and then the other party says, no, I don't want to attend physically, I want to come virtually. The judge also has to make a determination. But if that happens, then the one who has chosen to come physically is allowed to come with his witnesses, and then the one who doesn't want to go virtually, wherever he might be in the remote areas, then he has to go virtual. And according to the rules, there is supposed to be a police officer as well who is going to monitor that everything is going on smoothly, that the litigant does not influence his witnesses, and so on and so forth. So I think that is what the amendment has done. Then the amendment has actually revolutionized the way we do business in the courts. By the way, I mean the JSC as well, as a judicial officer. It has actually revolutionized. Some of us were quite skeptical about it, but once you actually have a feel of it, then you should actually own it. It has revolutionized the way we do things. It is no longer business as usual. Now, the timelines, for example, that is one, the timelines have to be followed. The litigants cannot forget about the matter and make the matter go on and on forever. If you go and log in or you put in a pleading, then the next stage will follow. Then it will actually tell you that the next thing that should follow is this one, and then and so forth and so on. So I think it has actually revolutionized the way we do things. It is no longer business as usual.
Yes, thank you. I'll now hand you over to the other commissioners for further questioning. Yes, DCJ.
Thank you, CJ. Good afternoon, Mr. Ndebele.
Good afternoon, DCJ.
I've one question, one general question. Despite your 26 years in the legal fraternity, as you put it, the papers that are before the commission indicate that along with this experience, this long experience, there were instances where you faced some disciplinary proceedings following some misconduct charges leveled against you, and the two I am zeroing in on relate to generally to abuse of JSC, your employer's vehicles, JSC vehicles. The one in 2015 where it is alleged, or it was alleged, you drove a vehicle, a JSC vehicle, for over 9,000 kilometers using your own fuel but without authority of the JSC or having the vehicle serviced. And there was also some damage that resulted from that use of the vehicle. You were found guilty and fined, and I don't know whether it was in respect of this one that you were barred from driving any JSC vehicle for 6 months. And the other, as recent, the other charge of misconduct happened as recently as April this year, where you were also charged with abuse of a JSC vehicle. And I think there are one or two other similar cases. So the question is, Would you say this type of conduct accords with the integrity, uprightness, honesty, respect for conditions of service that govern you? Conduct that is, does that accord with conduct that is expected of a judge of the High Court?
Thank you, DCJ, for bringing that to my attention. I am not aware of the second charge of misconduct that the DCJ is talking about.
It says the matter is still being investigated.
I have not been notified about that. So I cannot answer authoritatively on that because no one has actually brought papers. The JSC has not brought papers to me to say I actually abused the motor vehicle, maybe at Philaposi or something. I have no knowledge whatsoever on that, whether it's being still investigated or what.
It's fair enough, but perhaps what about the other one?
Yes, the
2015 one?
The other one, maybe if to put it into perspective, I do believe it is.
We're interested in is that you were brought before a commission of inquiry or disciplinary committee. You were found guilty. You were fined $250, something like that. So I am not expecting you to defend yourself when you've already been convicted and sentenced.
Yes, I was actually found guilty not for the allegations that were actually leveled against me and so on, because I defended that. What I was found guilty of ultimately, with the communication that I got, was that as I was actually moved to the regional bench from Cholocho, I did not do a proper handover, takeover with the magistrate who was coming in to replace me at that one-man station in Cholocho. That is what I was found guilty of. All these other things, I actually defended them. I was only notified that you did not do this. And the penalty that I got, which I did, was that I should pay a fine of $500, not $250. So the fine was actually levied on my salary for 2 months. Then I was barred from driving JSC motor vehicles for a period of 6 months. That is the sentence that I got. And now in relation to the question that you have brought, Honorable DCJ, is that conduct? How does that conduct sit with me as an aspiring judge of the High Court? I think that is water under the bridge. I cannot defend myself before because I was convicted and I never appealed. But I think I've actually learned. I actually learned quite a lot. The circumstances that led me to be given that motor vehicle are also water under the bridge. But I defended that, and I think I'm a better person when it comes to the use of JSC property. As to the second charge, I am not sure of it.
Yes, despite it being water under the bridge, as you say, but the question was, does such conduct accord with what is expected of a judge of the High Court? That is the question I'm asking.
Yeah, yes.
Whether it's water under the bridge or not, it was done.
Yes, DCJ, Honorable DCJ, that conduct, maybe from whichever angle it might be looked at, is actually doesn't sit well with the conduct of a judge. But then I think I was actually working in the lower echelons of the judiciary. I think I learned my lesson, and I don't think I will actually abuse or damage the property intentionally or negligent or in any other manner.
Yes, thank you. I think I'm answered. Thank you.
Thank you, Chief Justice. Good afternoon.
Afternoon,
Mr. Ndebele.
Honorable AG.
Yes, I've got one question to you. Please, can you give me 2 instances where an amendment to a charge in criminal proceedings is not allowed?
Instances
Yes.
where an amendment is not allowed. An amendment may not be allowed in criminal proceedings. I do believe that this amendment will be maybe brought by the prosecutor who will be in charge of that particular matter. An amendment may not be allowed to the proceedings if it is going to be prejudicial to the accused person. If the amendment is not going to prejudice the accused person as to his defense, then the amendment will be allowed. But if it is going to be prejudicial to his defense, then it cannot be allowed. I think, yes.
Thank you, Chief Justice, and good afternoon, Mr. Ndebele.
Good afternoon, Commissioner Masiemoyo.
I have one question for you, and the question goes as follows. What steps should a litigant who wishes to amend their pleadings take in civil proceedings in order to achieve a valid amendment of pleadings?
The litigant in civil proceedings who might want to amend his pleadings or her pleadings should make an application to the court. Maybe he can make the application during trial orally, or he may make an application in writing. And that amendment again should not prejudice the other part. The litigant will make an application and give notice to the other party to say, I'm going to make this particular amendment, to apply for this particular amendment, and I am going to maybe also tender court if that particular pleading has come after the issuance of summons. The litigant can also amend on application as well, Commissioner. Maybe it is the issue of, say, damages, and you want to amend the quantum of damages. Maybe the damages were in ZWL, RTGS, and now that maybe we're going to ZIG, you want to amend so that you get the true value of your claim. So you need to make an amendment and inform the other part that this amendment is going to be done, and it is taken to the judge to make a decision whether the amendment is not going to prejudice the other part or not, and then it will be granted. That will be my response, Commissioner Masiama.
Thank you, Mr. Ndebele. Thank you, Chief Justice.
Thank you, Chief Justice. Good afternoon, Mr. Ndebele.
Afternoon, Commissioner.
I have a few questions for you. The first one is, on your CV, you have a list of 3 referees, but the 3rd referee is a law firm. How do we consult a law firm for a reference?
Actually, I think that was the managing director of the law. Collect. It was that case kept there. Was pride. For review. Came back with application for review. So I was saying, so what do I do here? Because we had responded to the notice of appeal, and the record, the original record, had actually gone to the High Court for that particular appeal. We were preparing it, we prepared it. When we were preparing it, and we were about to send it, because the days for actually sending the record were closing by. We then got an application for review. Initially, the appeal was not on those
It's
grounds.
fine, I think
Yes.
I understand. So
Yes.
what it was an application for review against a decision that you supposedly had made.
It was
What can you tell us about the case of Thando Nhlizio? which apparently is an assault matter, which apparently has been outstanding for 3 years and 7 months.
Okay, Thando Nhliziyo. Thando Nhliziyo, if I may remember very well, that case should have come during COVID. If I can make a recollection, and that case then fell off system. After falling off system, the prosecutor who was actually dealing with the matter, although he could not have a partly head matter as a prosecutor, was a police prosecutor. He was then removed because of the Supreme Court judgment. Constitutional Court judgment that removed police prosecutors. And then after some time it was then brought, I think it was brought last year as a reintroduced matter. And now it is still there at the defense case stage because the accused person is desirous, has been desirous to call his witness, his defense witness. At one time he called the witness, and during lunch time,
it's fine, I'm answered. I wanted
yes.
to know why you finalized this case 3 years and 7 months. I now have my answer.
Yes.
The next question I have you taken fuel from a politician to put a JSC vehicle?
Yes.
What does the Magistrates Court of say about a magistrate accepting gifts from anybody? And in fact, what is the impact when you are accepting a gift from a politician or people?
Actually, the circumstances that led me to get fuel from the politician of Parliament in Felapo, maybe that is the source of the second charge. I don't know. We had an inspection in local, and I was supposed to do banking. What the politician then saw me, I think, the motor vehicle had no fuel. And then the MP saw me standing by the corner of the court, hitchhiking to town. And asked me, Mr. Ndebele, where are you going to? I said, no, I'm going to town. Transact some JSC business. Of course, I did not tell him that I was going for banking. The money was in my pockets. Then he said, why are you hitchhiking? And then said, we do not have fuel. We are yet to receive our coupons. Then, but you can't go to town hitchhiking as somebody who is a magistrate in this place. Maybe we can give you fuel. Then I might have been wrong in accepting that fuel. I was of the view.
But did you disclose it after you accepted it?
I actually did not disclose it, but I've disclosed it now. Earlier, when I was given the fuel, I did not disclose that I was given the fuel. I've actually asked the MP to actually write a letter or an affidavit to say he actually gave me the fuel in what circumstances, and it is there in black and white.
Thank you, Mr. Ndebele. Thank you, Chief Justice.
Yeah, thank you. Yes.
Thank you, Honorable Chief Justice. Mr. Ndebele, you are a resident magistrate.
Yes, Commissioner Ogwe.
What is the rank of a resident magistrate, if I can put it that way, or is it itself a rank? Is it a position?
Yeah, it itself it is a rank. It is actually a position, because a senior magistrate can be made a resident magistrate. A magistrate can be made a resident magistrate.
Are you a provincial a senior magistrate?
And then because I'm stationed, I'm the resident area. But it is the rank of administrator.
When I know you have been 23 years. Is that
Commissioner?
And would you say the fact that you have not managed to rise to the position of regional magistrate in 23 years is a reflection of fulfillment, something like that?
I say I didn't, but me at the JSC because I had been a resident magistrate lodge of the LLBS honors. Came back in when I finished in 2014. Back law made and
Mr. Ndebele, answer.
To just to add one or two sentences that can go to the regional and work that I did at one. I never got a white paper. 2, there was no appeal, and so on. So I was shocked when I was actually transferred to a smaller station to Western Commonwealth. I don't know, but it is no reflection whatsoever about my capabilities as a judicial officer. I think I'm very competent.
Thank you, Honorable Chief Justice.
Yes, thank you.
Honorable CJ, very well. My mic was flashing green. Afternoon, Mr. Ngwe. Mr. Ndebele. Very well. Sorry for that mistake. Settling cases is an important aspect of a judge's work. What would want to know is whether or not you have any experience in settlement of cases or mediation. If you have, how are you going to put that into practice when you join the bench, should you be recommended for appointment?
Thank you, Commissioner JP. I think I've got the experience in settling cases, both at the magistrate courts and also.
Can you speak up, please?
And also at the High Court. I think you will note first that I did a course. I did maybe a modular course in at the UZ of ADR, Alternative Dispute Resolution. So I noticed that when I went to practice for the matters law chambers, that particular experience of settling matters cases actually came handy. The mischief behind the settling of cases is that there should be finality to litigation. And I have noticed through experience that you have to settle a case wherever it is possible. You can actually settle a case maybe during the PTC pre-trial conference. You ask the parties to actually agree, make admissions and so on, curtailing proceedings. And by so doing, you'll actually be adhering to the principle of finality to litigation. I did a number of matrimonial cases, that is divorce cases, and I think one of the requirements is that the parties should actually have a round table in order to find out what can be settled and what can be taken to the High Court, to the family court. And I noticed through that particular experience, the negotiations that were taking place and so on actually assisted me in actually achieving that, and it is going to assist me in achieving that. And when I was a legal practitioner as well, I was involved in issues to do with a bit of labor law, where you will go to the NEC for a particular industry and try to settle issues before a certificate is issued or something like that. Then I noticed again that the experience that I had garnered throughout the years is actually very useful. Is invaluable when it comes to the principle of finality to litigation. I think I have got the experience to actually settle cases wherever the opportunity arises that the cases may be settled.
Mr. Ndebele.
Thank you, CJ. Mr. Ndebele, have you ever issued a sentence that was considered to be harsh to an extent that it was substituted?
Yes.
Maybe state one of that case and your reasoning very briefly.
Was it set aside? No, I don't think it was set aside. The case that I'm thinking about was not set aside by Justice Kavasa, although she wrote to say that you were harsh, but you were within your sentencing jurisdiction. I think it was a domestic violence case where the husband had actually brutalized the wife, and I used a judgment in Muchekayama, State versus Muchekayama. I think it was written by Makonese J. To actually, I wrote a beautiful judgment, I think, in that matter. So I then gave the accused, he was a family man, he was the breadwinner and so on, actually gave him a prison term, the maximum, and then suspended a year or so. And then I think Justice Kabasa looked at that. The conviction was proper, the reasoning was proper. It was before the sentencing judgment, the reasoning was proper, but she then felt that it was actually harsh, but was within my jurisdiction. So he actually ultimately confirmed it. That is one that I can think of.
Right, thank you for that.
Hello, Mr. Ndebele. Against a background of so many complaints that have been highlighted to you, can you convince us as a panel that you are fit to be recommended for appointment to the position of a High Court judge?
Thank you, Commissioner Chingosho. I'm not sure whether there are many complaints. I know of one that happened when I was at Cholocho that was dealt with.
Okay, I have got one here,
Yes.
which is the 10 January 2024 as a complaint. There is the
It's about...
But I think you were given an opportunity to respond to it.
No?
Yes. we asked about the Sheila Mpofu and Abednico Ndebele case.
Yes.
There was the issue of the motor vehicle, and what I'm referring to is against the background of all this, do you think you are proper to take up the position of a High Court judge? Even if it were one.
Or even if it were one. Yes, I know men which also includes women, judges, they are not saints. Men are not saints. There will be one or two instances where you might misstep. And I think this one of the Cholocho motor vehicle is one such misstep. And I don't think it can actually disqualify me from the position of the judge of the High Court, that particular one mistake. The Sheila Mpofu is not, to my understanding, a complaint. It is actually still pending at the High Court. The lawyers have not moved it. We have engaged the registrar. In fact, it was, I think, as recently as February or so, it was then removed from the roll for, it was struck off the roll for want of prosecution. They did not follow it up. So I do not understand how it can then be termed a complaint, because it was out of my hands. It was taken there as a review or appeal. The only complaint which I do not think affect my being appointed to this esteemed position of the judge of the High Court, the one for the Cholocho, I don't think it can stand on my way. And I do not want to say again, it is water under the bridge. But it is water under the bridge because it has been
Mr. David, I think I'm answered.
Yes.
Thank you.
Thank you, Chief Justice. I have no question. I'll pass.
Yes, thank you. Sorry, we have come to the end of your interview. You are excused.
CJ and